My lord, submission one.
Page adjournment.
On MFA matter, my lord, this matter may be referred to Lok Adalat, my lord. We just make,
No, this court is not having the rows prepared
well, it's already.
before the other court. Yes.
Page wise adjournment. Page 1, page 2.
No. This one. Tell Raghu so that it will be placed before the Lok Adalat. Tell to Raghu so that it will be attached in the Lok Adalat. Raghu. Raghu, tell him that.
My lord.
Yes.
Memo for the judgment correction, my lord.
Tomorrow. Yes.
Lord, cell number 9, my lords.
Oh, serial wise.
Please, my lord.
Yes.
Page wise adjournment. Page 2, serial number 2 to 5. Page 3, 6 to 14.
My lord, cell number 9, my lords. I'm a proxy counsel for the petitioner, my lords. Petitioner has moved the matter, my lords. Today there is a urgency, family emergency, my lords. That's the reason she couldn't appear, my lords. Kindly have it on Monday or Tuesday, my lords.
Inform the other side.
Please, my lords, inform, my lords.
At the request of land counsel for the petitioner, there's this matter on 17th.
My lords, on Monday or Tuesday, my lords, because the custody of a child we are seeking, my lords.
15th.
Grateful, my lords.
Page number 4.
My lord,
Serial number.
cause list number 1, serial number 15. We are going in for a settlement on that. We have requested the same in the family. To be finalized. We are working on a settlement between the parties. So if
Then why the memo is more?
that I'm not aware, my lord, I need to check with the opposite counsel because we have already informed.
Number 15.
Serial number 15 is
Please say for the
28769.
respondent.
I'm for the respondent, my lord.
I think there is a number is not correct. The
Sorry,
serial number.
28769, my lord, bar 24, Lakshmi versus Srinath.
Where is that? Serial number 15 is not that.
Apologies, my lord. I think, just give me one.
Just so they sought for time 9.
9. That petitioner counsel short time.
Just so they sought time now.
Right, my
That they-
lord.
it's not
I missed
when-
that. I missed that. So I would request one.
Tuesday, they asked for Tuesday.
My lord, give me a little longer date because it's going in for a settlement. We have already requested the time with the.
They have moved the memo and they wanted it to be Tuesday. We'll see on Tuesday. Yes,
Okay,
ma'am.
ma'am. Much obliged.
Page number 4, serial number 15 to 23.
My
Page
lords.
number 5, 24 to 26.
Appearing, serial number 23, my lords, appearing for the petitioner. My lords, there is an inconvenience for the arguing counsel, my lords. Seeker.
Who has moved the memo?
My lords, the other side has.
Then have you informed them?
Yes,
Lord,
my lord, I'll inform them, my lords.
Respondent, please, my lord. My lord, I have not moved the memo, my lord. In
Then
serial
who
number.
moved the memo?
My lords, then the petitioner may have moved the memo, my lords.
Matter on 14th of August
Very well, my
at
lords.
the request of land counsel for the petitioner.
Please, my lord.
Very well, my lords.
Yes,
My lord, serial number 26.
yes,
Serial number.
I appear for the petitioner, my lords.
yes.
I've informed the other side. I have some inconvenience today, my lords.
This is a matter on 11th of August.
Serial number 24, my lord. Today, Satyanarayana Swami Puja is there in our temple. I am in charge of that, at least any other day.
We appear for the respondent in this matter, my lords. Last time I had moved a memo and date was fixed. The interim order is operating. The date may be fixed for
Any other
tomorrow or
day.
day after
Tomorrow also I am ready because I already kept flowers, everything in.
Matter on 16th.
Obliged.
15th,
16th.
16th, 15th or 23rd. 15th also all right, my lord. 16th, but the ಬೇರೆ
Interim order is operating.
No, all the matter will not take up the matters according to your convenience every time.
In fact,
If your court is accommodating, come on 15th.
15th, at least 15th, my lord. 15th. 15th is all right.
Come on 15th.
15th.
You can't say that the matter will,
okay,
you will
madam.
hear them, we will argue the matter to you all the time.
Okay.
Yes, next.
Page 1.
obliged.
Page 1.
Interim order may be extended till interim order.
Model allow granted is extended till then.
For dismissal, serial number 1, Geeta Devi MP for petitioner.
I'm appearing for the respondent wife in this matter, my lords. Your lordships had directed to file a detailed assets and liabilities without suppressing any assets and liabilities.
There is a affidavit filed yesterday. Court officer.
Yesterday I filed in the counter, my lord.
Here.
My lord, may I make my submissions, my lord?
So let's look at that affidavit filed by you.
Lord, before I go to the affidavit, my lord, the affidavit was that I have suppressed information. I want to make a submission that we have not suppressed information, but we have not stated the amount that we have received from that sale. Sale has been mentioned in the assessor liabilities which we had filed. So now I have stated what it is. Lord, your lordship's order was to shall file an affidavit having correct statement of assets and liabilities and all other statement before this court, no property or other financial transactions will be suppressed by him, and companies which respondent wife is as business owned by him, whether it belongs to him or not. And that is the order of your lordship, my lord. A statement in form of affidavit to be filed before based on
Come to
this.
paragraph number 6, we'll see.
Please, my lord. In para 2, my lord, that I have not suppressed, and in my affidavit of
That I have
assets,
seen.
please, my lord.
Paragraph number
I have
6.
received a sum of rupees 2 crores, 10 lakh rupees as consideration for selling agricultural land in Tamil Nadu and rupees 4 crores as consideration for selling the apartment in Bangalore. I have repaid the car loans and house loans partly in meeting other contingencies which has come about to 2 crores in Indian rupees and US dollars to 2 lakh 50,000 rupees. I invested about 3 crores, 3 lakhs in business, a franchise agreement, postal next. Courier company in January 2024. I have taken a commercial space for rental and set up the establishment as required by the company. It takes 3 to 4 years to make break even from this business, and I am under loss from this business. This job keeps me engaged, and I have no income from this business as on this date. Balance sale consideration of $1,61,000 was with me. I have been paying for my living expenses that of my daughters in USA for the past 3 years. Purchase of car itself, I have paid $35,000 in past 1 year, and this amount is getting depleted for the children, my lord, car, both the children. After I lost my job in November 2022, I could not get any other jobs. At my seniority, it's very difficult to get a job in formal organization. I went into a depression and was struggling to come out to terms with my health and my career. I had responsibilities of my daughters also. I started looking for different ventures to generate income. I started leasing out my car and room in my house to generate income. I'm getting a sum of rupees 1,660 for rental of one room. I was getting $1,700 for renting out cars. This car met with an accident. I had to spend for the repairs, so I have sold the car. I do not get any income from the car. I've enrolled for a course in real estate and also opened a company in the name of Harmonia Estate LLC to do business in real estate. I had no experience and expertise in real estate business, and the real estate market was bad. Hence, I dropped the idea of real estate business. I affirm that I have no income from the business Harmonia Estate LLC. The renting of cars were done under the business name and style SJ Luxury Travels. I had sold BMW car and hence rental for car is stopped. There is no income from this business. The company named SNDK LLC is not run or managed by me. This company was renamed by SJ Luxury Travels and was used temporarily by me for a couple of years. I was leasing my cars and this has also stopped. I have nothing to do with the company S&D Consulting Incorporation. I am not managing the aforesaid business and have no income from the aforesaid businesses. I'm not having good health. I'm suffering from hypertension and diabetes. I'm under depression, taking medication to address these ailments. I'm on regular medication. I do not have any job, and I have to pay my home loan, insurance, meet other expenses, support my dependents and myself. I had obtained loan of one USD 1 lakh for my elder daughter's education. The said loan was originally taken when she came to USA to study her master degree course in September 2019. This loan was refinanced in 4/5/2022 for the elder daughter's education, and the details have been produced at Annexure F, Annexure 5, page 58, along with assets and liabilities. I paid the interest component for about 2 years. From the date of the loan in 2019, she started earning the year 2021. When the elder daughter was studying in the USA, I was paying her expenses that were not covered by her loan until she started working. The elder daughter Sanjana had completed her studies in the year 2021 and secured a job. And thereafter, she's paying the principal amount and the interest. I continue to be a guarantor of the loan. Even now, I support my daughter as and when the need arises. I helped the elder daughter purchase a car. I paid 13,000 US dollars and balance 13,000 as 2024, she joined University of Southern California for medical course MD. This course is for 4 years plus 3 years residency. The fees is about 1,10,000 USD, and I've arranged for a loan which will be sanctioned every year and must be repaid after she completes the course. I have to support all other contingency for the younger daughter. Every time she has to take a home for residence, I have gone to her place, purchased the required furniture and other household essentials for younger daughter, and this was done 2 to 3 times. Even now, I support this daughter when the need arises. I purchased a car for her this year, just 2 days back, a lot. When necessity arises, I paid 22,000 US dollars. She is not having any income, so I could not take loan on that. Lord, the point that arises for consideration, my lord, is that this application is filed by the wife. Admittedly, they are residing separately from 2013, and he is staying in the USA from 2015. So almost from 10, 12 years, they're separated. Now, this application is filed by her under section 24. I would like to make a distinction of section 24 and 25 as a proceed, my lord. See, section 24 says what is the income that is required for her support. Now, the first submission I would like to make, 3 submissions is what I'm making for today's consideration for your lordship. Number 1 is that the distinction between section 24 and 25. And then the question is what is to be considered in our application for maintenance is her needs. What are her needs and what are her resources or means if she has any. Number 3 is what are his means and his needs, his dependents, and what are his liabilities if any. And
20.
section 24. It is not that I have left her in the lurch. I am paying even when before I came here, even 80,000 I was paying, but then after the interim maintenance, I'm paying her 40,000. She has a home to stay also. Section 24, madam.
Yes.
Where in any proceeding in that it appears to court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support and the necessary expense proceeding, it may, on application of the wife or husband, order the respondent to pay to petitioner the expenses of the proceeding and monthly during the proceeding of such sum, having regard to petitioner's own income and the income of the respondent as it may seem to be reasonable. 2 points which I would like to highlight, my lord. It is for support and her necessary expenses. And secondly, what is the income that he is generating? So the question of going into his assets, if any, will come only in section 25. May I just read section 25? Thereto, an application made for the purpose of either the wife or the husband, as the case may be, order the respondent shall pay the applicant for her maintenance and support. The expression, my lord, is a maintenance and support, whereas earlier it was only support. Such gross sum of such monthly or periodical sum for a term not exceeding his life, the life of the applicant, as having regard to the respondent's own income and other properties. So there is expansion of the term income and other properties, if any, and the income and other properties applicant. The conduct of the parties and circumstances of the case, it may seem to the court be just and any other payments may be secured if necessary by the charge on the immovable property of the respondent. So, my lord, here whether we have to look into his income and is what I am submitting. My first point is section 24. We'll have to
think this is 24 is interpreted by the Supreme Court with several judges.
Please, my lord. Please, my lord. I'm not disputing on that aspect. All that I am saying is, my lord, that the roaming inquiry with regarding to his assets, if any, is it necessary or essential at this point of time is my first submission. Secondly, my lord, I'm not averse.
What was granted? What was the maintenance granted?
80,000 rupees.
80. You are seeking enhancement.
2 lakhs, my lords, was the application that I filed. I have filed a writ petition for enhancement and to allow my application.
So let's come to the order.
Para 29, my lord.
Yes.
The order is at page
Or
36.
shall we read from 22 to understand the facts better?
22, my lord. Please, my lord. At page number 22, reasons, my lord. Upon perusal of the affidavit of the respondent who has filed his application, is stated that her marriage was solemnized on 10/7/2019 in New Delhi. But in the wedlock, she has given birth to 2 daughters, Sanjana and Sunidhi, who were born on 93 and 1998 respectively. It's an allegation with respondent against him that the person having extramarital affairs. Even this day, he is living with his farmer by name so and so in his house at San Jose, California, USA. After shifting to USA, promised to relocate the respondent husband to and her daughters to USA, but he failed to do so because of his living relationship with his girlfriend. Respondent returned to India in July or August 2015. At that point of time, she was at matrimonial home. It's also admitted both parties for the children, who were then living with her in Bangalore and also clearing all the bills to matrimonial home. She also had access to add-on credit card to petitioner main credit card, but suddenly in the month of July 2016, he stopped all financial assistance. Again, from the month of July 2017, he reduced the maintenance amount to 1 lakh rupees, and he started harassing the respondent to give him divorce. She has stated in the month of March 2018, her elder daughter was residing with her in Bangalore and working in company. Younger daughter has agreed to study in USA and is gone to live with the petitioner. In 2017, the younger child is gone, my lord. Now, the respondent filed his application seeking maintenance by stating that the petitioner is successful company executive and is drawing salary and benefits of 1.55 crores per year in 2015 and probably might have increased in 4 years. Further, both are not disputed. The petitioners having number of properties are mentioned page 5 to 7 of various places in India and America. However, the respondent states the total worth of properties are about 12 crores, from which from November to March 2019 onwards, he stopped paying the said maintenance and completely till date is not paid the same, despite there are several mails in that regard. It's a case of the respondent that since the marriage, he's a homemaker and did not have any work for living. It's a respondent, the petitioner earning large income and was maintaining the family as standard successful senior executive working for multinational company is able to afford the maintenance sought by her. She is further contained that her younger daughter is studying in USA. The younger daughter is also going to USA to pursue her education. Totally, she stated that she would like to visit them as often as possible, at least once in a year, to spend time with them. Therefore, she needs a huge money as claimed by in the application. This being the fact, it's an allegation the respondent. The petitioner knowingly stopped paying maintenance of 1,50,000, suddenly reduced to 1 lakh. It's very difficult to maintain the entire family expense, including other expenses of her. It's also specifically said that the respondent, the petitioner is bound to maintain his legally with wife. If the application is allowed, no harm will be or injury will be caused to his processing. On the other hand, objection petitioners that maintenance and litigation expenses claimed the application are exorbitant. He admits relationship and the respondent is his wife and birth of two children who are presently residing with him in USA for study purpose as stated in the application. All the educational expenses offset from both the daughters are being provided by him only. Further, he admits that initially he was paying 1,50,000 towards maintenance of the respondent and her two daughters as they were residing in Bangalore. Thereafter, reduced the earlier maintenance to 1 lakh for reasons that his daughter came to America and staying with him. It's also stated that he stopped credit card access to pay additional bill from month of July 2016 as she realized that she was extorting money from him, threatening him and draining him in the name of educating the children. But she was holding the money and she has substantial savings from the money sent by him. It is also contended by the petitioner that previously he was working in India for a company called Citrix System and now is working same company in USA since March 2015, but denied that his drawing salary benefits of 1.55 crores per annum in the year 2015. Subsequently, increased salary for 4 years. His content is earning in dollars and expenses are also in dollars. The cost of living is high in USA. Totally is contention that though he is having the above and handsome income in dollars, respondent alone is living in the house owned by him and there is no need for making any higher expenses for the car, driver, other expenses. It's also necessary to discuss that though he is having number of properties in Bangalore and America, he has outstanding loan on properties and is paying EMI every month as stated in his objection. Presently, the petitioner has to look after the respondent by paying maintenance or has to look after his two grown-up daughters' education, forthcoming, and their marriage expenses. Further, it is stated by the petitioner that apart from he has to pay insurance of the respondent and therefore is ready to pay maintenance, but it is not possible for him to pay. As
Why you have not filed your statement of assets and liabilities before the court?
That time, there was COVID was there and he could not come because his job also was in flux. And if he had come, probably he would have lost his job. So when he came, now I have filed before your lordships, I have filed assets and liabilities. Before this honorable court in 2023, I have filed my law. Rajesh versus Neha's judgment came about during the COVID in 2020. That time there was travel ban, he could not come. And his job also was at stake, which happened. 2022, he lost his job.
This order is passed when?
4th of August 2022, my lords. And their writ petition is filed only in August of 2023, after a lapse of year.
Yes.
Inner assets and...
I've seen, I have read that, yes. The court takes an adverse inference that
adverse inference that we have not paid. We're not
paid, and it has to presume that you're having sufficient.
Now, and before your lordships have placed the assets and liabilities. Therefore, my lord, one point is that your lordship may permit me to take your lordships through the assets and liabilities, or this matter has to be reconsidered by the family court. That's the other option. My lord, before I could go further, my lord, The point is that now at this stage, she's also filed for divorce. He has also filed for divorce. Both of us are seeking for divorce. The scope would be thus limited to maintenance alone. So if the council is agreeable, the parties are agreeable, then even the entire matter can be focused only on the maintenance aspect or alimony if at all she's seeking for, and it can be narrowed down to that topic, my lord.
My lords, sufficient mediations have happened. I'll show before your lordships what is the conduct. Once my learned friend finishes argument, I'll show the conduct.
It's not that. What she says is, no, both of you have filed for divorce. What are your terms of settlement?
I'll bring it before your lordships. I want to show the conduct of the petition. Once my learned friend finishes the arguments.
She has completed.
My lords, I'm filing a list of documents which the petitioner has not filed before this honorable court in respect of his assets and liabilities. I'm serving the copy to my learned friend. If your lordships permit, in 2 minutes, I'll just tell the facts of the case. My lords, as of for today, it is 33 years of marriage. They married in 1992. Everything was fine until 2010. 2010, he comes in contact with his paramour girlfriend, whom he was in relationship during his college days. She applies for divorce, and that's when he comes into contact with her in 2010. Until 2010, everything was good for 18 years of marriage. 2010, he starts moving to US every now and then because the paramour lives in the US. In 2010, for 6 months, he used to live in a year in US and 6 months in India. Thereafter, in 2015, he completely moves to India, to US, because she obtains a divorce from her husband in 2013. Thereafter, they start living together. And even as per their assets and liabilities, he lives in a house which is jointly owned by him and his paramour. In respect of the businesses that he's done, which I have proved before this honorable court, that businesses are also run along with his paramour. Now, my lords, since 2010, once he starts getting in contact with his ex and starts meeting her and living with her in the US, that's when he makes sure that all the properties, as much as possible, which is in the joint name, is converted into his personal names. The documents that I've produced before your lordships, may I request your lordships to kindly look at document number 2. Actually, what I did, my lords, document number 1 is an entire bundle which I've already filed before this court. For the sake of convenience, I put that also together. Document number 2 is the sale deed. This is dated 3rd October 2013. Page 31, my lords. Page 31 of today's documents that I've produced. This was a joint property which was in both of their names. He ensures that a sale deed is done. Thereafter, next property, my lords. Your lords will have the next at page 48, my lords.
Yes.
That is again a property which he sells, which was in joint between the parties in 2010. My lords, thereafter, I have produced before your lordships an agreement to sell in respect of a flat in Gurgaon, which he enters in 2012. My lords, in 2010 and 2013, he sells the properties, capital gains, because you have 2 years to use the capital gains. He starts investing in his name in different properties. They have not disclosed this property before this honorable court, even though in my assets and liabilities, I have categorically told this property is there. Your lords may have that at page 65. This is document number 4.
Yes.
This is a flat for which he enters into an agreement to sell on 27 December 2012. This is a flat of super built up area of 1,660 square feet. Another property he enters into a rent agreement to sell again, which he has not disclosed before this honorable court. Your lords will have that as document number 5 at page 96.
Yes.
This is one Paris juice company for which there is an allotment, and also there is an demand, the receipts of the payments and agreement to sell, buyer's agreement, which is at page 104. This is also in Gurgaon. Doesn't disclose before this honorable court about this property as well. My lords, your lordships, on 18/6/2025, after me making categoric submissions and the document which is annexure 1 that I have produced, telling that he has properties other than what he's disclosed, and also he has businesses other than what is disclosed, your lordships had categorically told that you should not suppress anything and disclose about the properties. Now your lords may kindly have document number 7, just like how he started selling the assets which were immovable, he started selling the immovable asset also. At page 153 is the Toyota car Corolla. For this, he gets 11 lakhs and he accepts that he has received 11 lakhs at page 155. Your lords will have where he sent an email saying at the bottom, I have received 11 lakhs credit. Please send me the Sandward transfer documents. After this, what he does, he buys another property, which is Mantri Espana, which is sold in 2022, which I brought before this honorable court. That entry is at the document which I've produced at document number 6. Your lords may kindly take page 125, my lords. At page 127, when did the petitioner husband buy this property? Reference is at the bottom, my lords, that the seller herein, as per the sale deed dated 10/5/2013, executed by Mantri Apartments, he purchased this property, which he sold in December 2000. So in 2000, by 10/9/10/11/12/13, he ensured the joint properties are sold how much ever he can and purchase properties in his individual name. This Mantri individual name. This Mantri Espana, which I mentioned before your lordships on the last date, was sold in December 2022. Which they had not mentioned in their assets and liabilities. They only told they had mentioned sold. For how much? They did not produce the document. First of all, their assets and liabilities are not as per Rajneesh versus Neha's judgment. It is as per some Delhi High Court judgment. That is not what their lordships had told them to file, and that is not what they have filed. Now, my lords, they, in the fresh affidavit that they have filed, they told that they have sold another property and 158 and 157. I'll show you how the transactions have happened. If your lords can see, this is from an entry where this property was belonging to his paramour Deepika Chopra Ramalingam. She got this property as alimony in 2013 from her husband Ramalingam. That is there. It says that inter-family deed transfer. Post which, in COVID, they say that they did not have time to send assets and liabilities to India. On the next page, your lordships, in COVID, on 10/11, I mean, even in the US, either it's October or November, even if we move this side, that side, of October of November 2020, this property is transferred in the name of the petitioner husband herein and hasn't disclosed till date about this property. Your lords may kindly take to the next page. I had produced a document on 10/2/2025, a business of postal annex, and I produced only one franchisee document, even though I did have other document.